Yes, yes, you are.
Okay. Start the live exactly at 7, and if possible, share your screen and okay, 1 minute. That's gone to Ritin.
Yeah, okay.
Where is Ritin? Good evening, everyone. Am I audible, Riddhi?
Yes, you're audible, Shravan.
Thank you. A hearty welcome, everyone. I'm P. Shravan Kumar, the founder and CEO of SK Associates and Group, an ex-analyst at Citigroup and JP Morgan, the leading Wall Street banks of New York Street Exchange, and an ex-associate solicitor at the Supreme Court of India and the Karnataka High Court. I'm your host for today's conference 0.6, an international conference on emerging judicial trends in arbitration, mediation, and dispute resolution. SK Associates and Group is an ISO certified management consulting firm registered under MSMED Act 2006 with the Government of India. We provide management consulting services in the domain of compliance, operations, marketing, research and development, human capital, strategy and operations to budding student entrepreneurs across the nation. SK Associates and Group was formed with the dream to provide consulting services to budding student entrepreneurs across the nation and help them in developing the national economy by establishing their dream firms across various industries. We work with startups and train potential student entrepreneurs from various universities who are aiming to bring a significant change either in their business model, in scale of operations, or both. To succeed in this endeavor, however, our clients need a specific type of consultant, someone who is a problem solver. Typically, such a person is entrepreneurial and passionate, thinks out of the box, has an idea where the problem lies, how to analyze it, and most importantly, what would serve as a perfect solution for it. Such people have lived and worked in different countries and have got the scars to show for the risk they have taken. We call such people transformational consultants. We have worked over the last 3 years to build a network of such people, reaching out to such individuals across universities, across industries, and across the gamut of functional roles. Time and again, we have seen magic happen when we find the perfect solutions for our clients. This is what drives us and keeps us motivated each day. We are passionate and excited about the impact such individuals can have in building the next generation of iconic organizations in the corporate sector. Our mission: we aim to mentor 3 lakh students across India by 2026 by providing them with consulting services in strategy and operations, human capital, compliance, legal advisory, research and development, taxation, marketing, and help them in establishing their ventures by investing 20 crores INR in the startups over the next 5 years. We also aim to provide 50,000 employment opportunities to various lecturers across the nation by providing them with multiple volunteering chances. We strongly believe that strategic alliance and collaborations shall help us achieve our vision in working for the cause of global economic growth. Our executive management and operations team are always dedicated on working towards entrepreneurship development and community impact with a concentration on the point. Students are the upcoming future generations of our nation and need to be empowered for global economic growth, as is the vision of our Honorable Chairman. Now, I would like to introduce all our honorable guests for today's session, post which Advocate Riddhi Bhanushali from the Mumbai High Court, my co-host for this conference, would take over. Firstly, I would like to introduce Mrs. Sonal Kharbanda, the founder and CEO of Rectitude Idea, a unique startup offering alternative dispute resolution services in Delhi. Being an alumni of DU and the wife of Lieutenant Colonel Jogesh Khurana. Mrs. Kharbanda has previously worked as the Additional Standing Government Counsel for conducting the central government litigation and cases filed against public officers at the District Court of Kozhikode, Kerala, from November 2009 to 2012. She has also worked as a mentor and teacher at various schools for the cause of educational empowerment in students and is very passionate about mediation and dispute resolution. Our next guest for today is Mrs. Brenda Edith Vargas Almanza, who is also an international lawyer with a master's in alternative methods of conflict resolution and a diploma in negotiation and conflict resolution in organization. Brenda is a certified mediator and cyber mediator for ODR Latin America and ODR Spain. She is an honorable member of the International Forum of Professional Mediators and a university professor of public health policies for residents in the specialty of quality in clinic care, UDM. Being a public servant of the IMSS for 32 years, Mrs. Vargas is currently the head of the Division of Legal Affairs of the UMAE Hospital de Cardiology in Mexico and the notable ambassador of peace of the Latin American Confederation of Writers, Artists, and Poets in the world. Our next guest is Dr. Charlie Gaiden from Euclid University, France. She was born in Alberta, Canada, and is an academic author and former lawyer. She is a faculty member at Euclid University, France, with previous academic experience in England, New Zealand, and Canada. She studied and obtained a Bachelor of Arts in English and Political Science and a Juris Doctorate in Law. After receiving a Rhodes Scholarship, she continued legal studies in Oxford University, England, where she obtained a further law degree. In 2020, she obtained a doctorate in mediation and conflict resolution. Charlie will speak to us about two books published in 2021, Creating a Masterpiece, The Arts and Conflict Resolution, and Life on Planet Earth, My Story. Our next guest for today is Mr. Ashok Panikkar, who is a conflict resolution professional with extensive international experience in India and South Asia, the USA, and parts of Europe and the Middle East. He is the founder and director of Metaculture, a pioneering organization in Bangalore, India, that helps communities and organizations improve their higher order thinking and relationship building capabilities. Prior to this, he served as the director of training and workplace mediation with a conflict resolution center in Cambridge, Massachusetts. He has conducted hundreds of workshops in communication, conflict resolution, critical thinking, and cross-cultural engagement. He has also successfully mediated disputes at every level among board members, between staff and management, and at the community. Now, I would like to invite Advocate Riddhi Bhanushali, the Chief Strategic Alliance Advisor of our team from the Mumbai High Court, Maharashtra Bar Council, to take over. Yeah, thank you. Riddhi, if you could just unmute yourself a bit.
Yes. Greetings, everyone. I would apologize as there are a lot of network issues going on at my place. I would apologize for the same. I would start on again. Greetings everyone. I'm Advocate Riddhi Bhanushali, the Chief Strategic Alliance Advisor of SK Associates and Group from the Mumbai High Court. I'm a member of the Maharashtra Bar Council and Shravan's co-host for today. Being an attorney at law myself, I'm very well aware of the importance of arbitration, mediation, and dispute resolution, and hope that this conference helps all students, scholars, and lecturers across the globe understand the emerging judicial trends in the domain in this detail. Now, I would like to invite Mrs. Sonal Kharbanda, the founder and CEO of Rectitude ADR, to commence her speech.
Good evening, everyone. I hope I'm audible. Good evening, evening, everyone. First of all, I'd like to
You're audible.
yeah, thank you so much, Niti. First of all, I'd like to congratulate the organizers for giving us this opportunity to new startups like myself to share our views on this wonderful platform globally associated. Keeping the time constraint in mind and the paucity of it, let me get started. I would briefly be speaking on the role of judiciary in a country and how ADR methods are ancillary process to the main legal structure, also the trend in India towards ADR. I would also briefly talk about the international commercial arbitration and its role in dispute resolution worldwide, and how India is yet to make its mark in the international domain. Further, would like to talk about private domestic mediation with respect to India, its role and need for the same. I would conclude with my views on peer mediation and a topic close to my heart and its need in today's times with respect to the changing relationship demographics in society. Excuse me. First of all, I'd like to speak on the role of judiciary and how ADR is ancillary to the judicial process. Well, we are all aware that the judicial system of any country. Yeah. Thank you so much, Ruti. Just a second. Yeah. Thank you so much, Ruti. Now, first of all, the judicial system of any country is one of the pillars of the foundation on which the country's sovereign republic status rests. Whereas the constitution is what, Riddhi, you can take the second or third slide, please. Thank you so much. Yeah, whereas the constitution of the country is what guarantees the basic rights and fundamental establishes the fundamental duties of the state. The judicial system of a country is what gives the sacrosanct to those rights and duties, playing a very important role, being the interpreter of a country's constitution, as well as creating new laws, also overruling the policies that might be detrimental to the rule of law. Further, the rights against rem, that is the crime committed against the society or the larger part of the society, can only be decided by the courts or the judicial system of any country, which has the rights to impose penal actions thereon. Now, judiciary also has an advisory role to the executive or the legislature of a country. With such a wide and diverse role of judiciary, when we look at an alternate dispute resolution system, as the word suggests, gives an alternate system to resolve disputes or conflicts through its various methods. However, it cannot and should not be understood to be an alternate to the main judicial structure or the justice delivery system. It's a procedure for settling disputes by means other than litigation. The ADR ethics of confidentiality, neutrality, and party autonomy could be said to be supplement to the main judicial system of a country, but cannot and should not be understood to be an alternative to the judicial system, which in itself has a much bigger and broader scope and importance for the legal system of any country. Now, although being an important tool in the justice delivery system, ADR cannot completely oust and it is not completely able to hold the baton in its hands. This has to be understood. Now, when we talk about the Indian context, the ADR, the role of the ADR system could be said to be providing a much needed breather to the already burdened judicial system and its scope has immensely increased with the pandemic necessitating the role of ADR in multitude. In India, most of the universities and law colleges, realizing the importance of ADR, could be considering to introduce ADR as a subject matter of their curriculum. It has also been noticed that mediation is being promoted at university level in as much as mediation competitions are being organized to create awareness in this ADR method. Hopefully, by the turn of 2022, we could see an important change in this dispute resolution system and ADR could be considered as a necessary service to the nation. Now coming to consider the role of international and domestic commercial arbitration and mediation. Yeah. Riddhi, you can, next one. The next one. Thank you so much. Well, in terms of international legal system, whereas some countries follow the civil law, the others follow the common law. There being no uniformity of laws and the legal procedures of each country. It is pertinent to note wherever there is international trade and commerce flowing, there are bound to be disputes between the parties. There being no common method of absolving or resolving these disputes. In such a situation, one of the key issues of international trade dispute is under which country's legal system should the dispute be settled. There is an inherent fear in both the parties that the native countries would favor their resident of their country, and this fear is not unfounded. Further, there is a fear that the court might lack connection with the subject matter of the dispute or with the parties. International commercial arbitration addresses these concerns of the parties, breaking the barriers of different nationality, legal background, linguistic, and cultural differences. It provides a binding decision to all the signatories of New York Convention. The arbitral tribunal gives a binding award not ordinarily subject to appeal and an award directly enforceable in the domestic and international domain. International arbitration also allows flexibility to, I would like to take the questions at the end if that is possible. International arbitration allows flexibility to hold the arbitration proceedings in any country of the choice from all the countries that have signed the model law. It scores over courtroom trial because it provides the parties confidentiality to their dispute, which is never available in the courtroom trial. There are many trade secrets and competitive practices which the parties may want to safeguard and not disclose the same for the fear of being subject to adverse publicity. The biggest advantage of India's international commercial arbitration is the flexibility to choose from a pool of experienced arbitrators with a business mindset who are inclined to speed up the arbitration process. They very clearly know the ethics of international arbitration, and this acts as the biggest advantage. The parties can take help from arbitral institutions globally renowned for their professional expertise in dispute resolution. Now, unfortunately for India, we have not been able to create a major impact to the full potential mark in international commercial arbitration. In the context, the potential India could promise to the world community. India is still not a preferred seat of arbitration as far as international trade is concerned. Now, hopefully, this could be addressed by the promising position international mediation could hold with the signing of Singapore Convention. Moving on to domestic mediation, this is what catches interest in the current scenario, and rightfully so. Whereas the need and importance of both commercial and family mediation could not be underlined, what interests me more and I like to speak on is domestic and family mediation. Family mediation till date is the domain of court and ex mediation, especially in developing countries like India, where litigation is considered as a preferable means of dispute resolution. There being absolutely no or minimum awareness in the local masses about mediation. Also noteworthy is that the dispute which does come in the domain of mediation has already suffered the trauma of going through dispute trials at courts, it does not come for through the dispute trials at court, and when it does come for the resolution, it has already surpassed every hope of peaceful resolution. The relationship is already so that the mediation first go through a challenge of undoing that harm that has been done in the process. So much so that the parties to the dispute now see each other as enemies. Now, whereas our aim as mediator is to separate the person from the problem and give a holistic healing approach to the relationship, so that the problem is identified and resolution is reached with parties in consonance, resulting in a win-win situation for both. However, same becomes very difficult to achieve, since the parties have already undergone through a bitter experience of fighting the legal battle or are ready with the mindset to fight the legal battle. Aim of mediation should be that the dispute should not reach at that stage. That requires first to heal the relationship to be able to even resolve or even to identify the issues. If mediation has to be considered as a first means to dispute resolution, then socially we should be looking at a much healthier approach to resolve the dispute before further disintegration happens in a relationship. Now, in my opinion, if we have to see mediation and other dispute resolution services ethics as a service industry and a very valuable service to the nation and global community, we have to understand that it is perfectly normal for a person to be in dispute with another human being. If we have a financial crisis, we consult a financial advisor. If we have a health issue, we seek the guidance of a medical expert. Then it is high time for our relationship issues. We have to seek the guidance of a domestic resolution specialist to help us first identify the problem and then facilitate the parties to find a solution to the problem. If we understand that the dispute always starts with a problem needing a solution, how justified it is that the parties become part of the problem and not the part of the solution. I guess one role the mediator plays is to take them through this journey, whereas it is only imperative to find a solution to the existing problem by not starting the blame game or trying to shift the focus by punishing the person, who invariably is also looking to find a solution. Both the parties to the dispute here need to look at not at the right and the wrong. They both have to realize that they both could be right and they both could be wrong. I would reiterate that mediation is a very beautiful journey with dispute resolution peacefully and following a more pragmatic, more logical approach. Further, the outcome could be more practical, less penal, and more friendly for the parties. Well, in the Indian context, hopefully the new mediation law coming up would encourage private mediation, and mediation would be seen as the first and the most preferred means of dispute resolution for both family and commercial disputes. Now, taking mediation further to peer mediation, the need of the times in our society. Well, with the human revolution, we have seen that human relationships are also going through an evolutionary phase. What started off as a joint family system disintegrated to a nuclear family, and now single parenting is becoming the norm in society. With new concepts of center parenting, where one parent has visitation rights on specific occasions. All this is leading to parent alienation cases on the rise, especially in divorce and domestic violence cases. It is imperative to note that the changing dynamics in the society have led to an emotional vacuum being created in the periphery of children. We have seen rise in the cases of violence and brutality, both at schools and university levels. Well, all this necessitates the need for the society to pitch in to provide a holistic environment in schools and educational institutions. This is where the role of peer mediation comes up. Basically, we have to unlearn the behavior of bullying and cynicism and inculcate the habit of empathy in our children. The schools are the first place where a child gets his first societal stimulus. And unfortunately, this is also the place which could result in a lifelong trauma in children and later grown-up adults. The psychological and psychosomatic effects of an early age trauma manifest in attitude and behavior manifold at later adulthood subsequently. Now, whereas in my opinion, the eradication of wrongs prevalent in the society is a tedious task. However, implementation of good social moral virtues could bring about a positive reinforcement of such values, and hence be a more pragmatic approach to achieve the desired outcome. Worldwide efforts are being made in this direction, and mediators around the globe are joining their hands in their drive to make this globe a better place to live in. Hopefully soon we will see a positive effect when such efforts start bearing fruit for the benefit of humanity. Now with this, I conclude my talk on trends in ADR. I took you through a journey of how judiciary and ADR are associated and how international to commercial arbitration could be useful. further domestic mediation and peer mediation, how they are useful for the society. Thank you so much for your patient listening and much regards. Thank you. Vidya, I think I'm done. Is there any question, or do I have to answer any?
If there are any questions, you can kindly ask, ma'am, and we can carry on. Students, any questions?
I think it was a journey, almost like a graveyard.
Okay, it seems there are no questions from student side. So moving on further, I would like to thank you, Mr. Sonal Kharbanda, and I would like to thank Mrs. Sonal Kharbanda for her amazing speech and the useful information she shared with the audience. Now, I would like to invite Mrs. Brenda Vargas, an international lawyer and mediator, and the ambassador of Peace Latin American Confederation of Writers, Artists, and Poets of the World, to commence her speech.
Can you hear me?
Now we can, but you were on mute before.
Excuse me.
Okay, you're okay now.
Hello, my name is Brenda Vargas. I'm a lawyer and certified mediator. I'm from Monterrey, Nuevo León, Mexico. I'm so happy to be here with all of you and to have the opportunity to participate in this great event. I really appreciate the invitation. Before start, I would like to offer an apology in advance. Spanish is my mother tongue language, and I am still learning English. Therefore, I will do my best. I hope I can make myself clear. Thank you for understanding. The next, please.
Terry.
Yes. Right. What is mediation? Mediation is a communication process to solve problems, even though it also represents an option to change the way of communicating in a positive way with each other and be able to change lifestyle, paradigms, and the rhythm to which society communicates. Excuse me. This as a preventive and positive way to avoiding conflicts and generating a culture of peace. Next, please. Mediation in Mexico. Legislation. Article 17 in Constitution of the Mexican United States mentions the alternative methods for controversy solutions. In Mexico, we have abundant legislation in matter of the mediation. This is because each state has its own legislation in alternative methods for dispute resolution, such as mediation. Each state of Mexico certifies mediators. In Mexico, mediation starts in 1997 in Quintana Roo, just where Cancun is located. It is important to mention because Jorge Pesqueira is one of the most recognized professionals of mediation in Mexico because he created restorative justice and associative mediation. To get in context, I would like to visualize Mexico's map, which is divided in 32 states. It is important to mention that in Mexico, each state has its own mediation legislation, which means that if a mediator wishes to be certified to practice mediation, they must certify in each state. I find important to mention this point because different from the other countries, in Mexico, it is a requirement to have a specific certification from the state you want to work as a mediator. Next, please. Currently, in several mediation centers in Mexico, it is possible to practice mediation in the following sectors: familiar, scholar, community, criminal, indigenous. The challenge for mediators is to work hard to expand mediation to solve problems in any profession, such as engineering, architecture, restaurants, in the health sector. If it is possible to make mediation between countries, why wouldn't it be possible to practice in your daily life? Objectives of mediation. Some of them: conflict resolution, approach between parties in a conflict, reduce the amount of work in the court, oriented to achieve agreement in matters not bound by the law. Avoid the damage of the relationship between the parties, educational transversality to solve problems in culture of peace, just to mention a few. Next, please. Next, please. Could you hear me?
Yeah, Riddhi, can you please move to the next slide?
Yes, Shravan, there is a network issue from my side. 1 minute. Sorry for the inconvenience.
Okay. May I continue? Yes. Guiding principles of mediation, a peculiarity of mediation and their principles is that they prevail universally. Some of them are untiredness, confidentiality, neutrality, flexibility, just for mention some. Why am I passionate about mediation? I'm convinced that in the matter of conflict resolution, the main goal is conviction. With the reflection that you get from both parties, you get also the transformation in their interest, and it leads them to stop thinking only in themselves. Still, if no agreement has been reached, how can we support mediation? What do we need to do? What do we need to do? I think we need to work more in the fusion of mediation process to generate interest in people. It can be practiced in hospital, sport, schools, architecture, engineering, etc. Different professions face problems every day. and in some cases, they could try to solve them by using mediation, even if both parties don't reach an agreement. They won't lose anything because they have already tried to take care about their relationship with each other. We as mediators have a duty to make diffusion about mediation in such a way that new generators can feel. Excuse me for my pronunciation. I hope you can understand. Can feel familiarized with the mediation process so that in any conflict situation or problems they consider as a first option appealing to a mediation process instance to thinking of requesting a demand as nowadays that most part of the population is used to it. We need to stop seeing mediation as a secondary alternative for conflict resolution. On the contrary, making the demand the second one. Nowadays, it's unbelievable to realize that there exist lawyers in the practice of the profession that do not know about benefits and scope of mediation. For instance, they don't consider it as an option. The COVID pandemic has brought pain and loss to humanity, but at the same time, it has also brought positive things. As an example, social media has become the main character by shortening distances and breaking borders. And a clear example of this is to have the opportunity to encountering ourselves from different countries and different continents and be joined by the common point, which is mediation. Mediation has been possible also because social media and online platforms like Zoom, for example. Initiatives related to online mediation have been generated. For example, in Latin America, Alberto Elizabetsky and ODR Latin America provides training services to mediation professionals from anywhere in the world, as well as a global registry of mediators, with the great opportunity that these represent. The next, please. You are cordially invited to Mediation World Conference happening on April 26 to 28, in which I will participate. For further details, you can contact me on the email on the last slide. Today, it's time to change paradigms, to dialogue, to learn to communicate in a different way, in a positive way. Today, it's time for mediation. For any question, please feel free, send me an email. Thank you. Thank you.
Euclid University, France, to commence her speech.
Yes, it sounds like it's now my turn to speak. Can everyone hear me? Good, that's good. I was wondering about the audio, but I'm very happy that it is working. First of all, I want to say that I'm honored to have been invited by SK Associates, as well as the group that is with me and the young people that are listening to this presentation. Now, I have provided a PowerPoint, so I hope that it's with me and we can follow through with it. But I want to say, as I had mentioned, I'm very honored to be with you. And what I want to talk about today is the emerging trends in mediation, arbitration, and dispute resolution relating to climate change. Because as the United Nations has indicated, this is the pressing issue of our time. So if I can just go ahead with the PowerPoint, we'll go to the first slide. This is just the introduction. So as I've already indicated, I'm talking about the trends in all of these areas: mediation, arbitration, dispute resolution. And I'll provide you 3 examples. So the next slide explains the 3 examples. Can we move to the next slide, please? The next slide. Okay. Great. Thank you. So I'm going to be talking to you about international matters, national matters, and I've restricted that to France, because at first I started looking at India and I said, hold it, I'm with people that know a lot about this, so I need to focus on something that they want to hear about, which is where I'm from. I'm living in France. I did sort of move to Canada first, and I said, no, I used to live in Canada, but now I live in France, so we'll talk about France. And then the final third issue that I'm going to deal with is education. So if we can now move to the next slide, I'll start with the 3 comments that I want you to be aware of throughout my presentation. Please think of these 3 things. Please comment on the 3 examples that I provide: international, national, and education. And then, are we moving fast enough? And the third question I want you to write down, consider, and think about when we have a time to work together is what more needs to be done. So with that, we'll move on to international. So if you can go then to the next slide, and we'll talk about international law and mediation. So we're talking now I tend to be focusing a lot on law, but mediation, I roll into law. I roll mediation, collaboration, and arbitration all into litigation as well as another method, but I roll them all together and I say, all right, what can we do in this area of international dispute resolution? So I start with the fact that we're looking at the United Nations Framework Convention on Climate Change and the Paris Agreement when we're looking at climate change. And one of the things I want to share with you, and for the students who are with us today, this is my most important comment to you, is that this is the fastest growing area of international law. That is, environmental international law is the fastest growing area. That's what the statistics are showing us. So there's a need for international environmental lawyers, and there's a need for academics. And you're going to hear from me that the university I'm working with is asking you to join. If you're an academic that has a doctorate degree in climate change, sustainability, please make an application to our university. So I'll ask for the next slide, please, and we'll talk about what the United Nations Secretary General has to say about mediation. So to show you that Antonio Guterres, the Secretary General, has said, he's highlighted that mediation is a very good method that can be used to deal with climate change disputes. Now, I say, well, I don't have to say that, but people might ask, well, why is that? Well, obviously, it's less expensive, less time, less costly, and it doesn't get you sort of tied up in litigation. Because what happens in mediation, the people stay in control. So you're not dealing just with arbitration where you give the control to someone else. You maintain control. All of the stakeholders maintain control of the situation. So that's one of the things that the Secretary General has pointed out, that we need to let the people look after their own issues. And what he has said, these are his words: given the complexity of conflicts, mediation is no longer an option. It is a necessity because we don't have all of the resources in the world to go every case to litigation and fight it out for about 3 or 4 years. We need to deal with things now. And so that's one of the great advantages of mediation. So I will ask for the next slide, please. So I wanted just to mention that the Oslo Forum, which is a group of mediators that meet annually, that they first put climate change on their agenda in 2019. So you can see in the space of 2019 to this year, 2022, it has just been skyrocketing, the need for people speaking about mediation. And so it is something very important for the Oslo Forum, and I'm sure it's going to continue to be so. I also want to mention that the UN has great resources available to you, students who are listening to this presentation. You have material that has been put together as booklets about how to mediate climate change natural resource disputes. This material has been put together by the UN, something available to you. And so it's something you can work with quite easily. The other thing to note, because there's possible jobs here for you, is UN high-level mediation experts. They're looking for experts in these areas. As we are at the universities, as the world is, we're looking for experts in climate change and sustainability. And you, the people who are listening to this presentation, are going to be the experts. So I welcome you to join me in the next, in perhaps some of my courses that I teach. So I'll ask for the next slide and we'll move on. The next slide, please. Okay, here we are. We're now at national. I'm watching my time quite carefully. I'm going to, back to the last slide. We're going to talk about the Affaire de Siècle. This is in 2021. What happened is the French government it has great objectives for what it's going to do about climate change. Well, great objectives is, as Greta Thunberg said, there's a lot of blah, 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 talk. But objectives are one thing. You have to put your feet to the fire, and what are you doing? So the case was brought in 2021 by Oxfam and Greenpeace and 2 other NGOs, and it's called the Affaire de Siècle, and it went to an arbitration tribunal, the Paris Administrative Tribunal, and the decision was Paris had great objectives, but it's not doing enough. It's not going to meet the demands of reduction of CO2 by 2030, 2050. It needs to step things up. So that's the decision. The similar decision the same year, a few months later, July 2021, the Commune de Grandsins and France, same decision. This was a coastal community that said, you're not doing enough for us. We're going to be washed away if you people don't do something. And sure enough, this was the court that said, yeah, France is not doing enough. So now let's go to the next slide. We'll see what France is doing. Okay, so I'll take you to the next slide, please. Next slide. Oh, great. Thank you. So what's the French government doing now? Well, it started a citizens coalition to get advice from the people across France. And so 150 people made recommendations to the government. In July of 2021, new legislation was passed to try and say, okay, here are the things we're going to do. I was really happy to receive a bit of material that says, pretty soon we're going to shut down these cars that emit too much CO2, and so you have to buy new cars. So I thought, okay, great. But now what's really going to happen and what will answer the question is this year, 2022, there's going to be an election. So we're going to see whether or not the Macron government, the President Macron and his government is going to be able to meet the demands of the courts. And if not, then the people are saying, okay, can we find someone else that can do better? Maybe not. We don't know. So that's going to be a question that you can watch in the next few months. So we'll go to the next slide, please. My next slide, please. Can we get to the next slide? Oh, no, we're stuck. I don't have control over the slides. I think we're just about into education, but we can't seem to move to education for some reason. Do you want me to just speak? Oh, here. Oh, we've lost the network connection. Okay. I can just move on because I don't want to hold up other people. I'll just move on to the next slide, which is fine. Because we're talking about mediation and education. Okay, in mediation and education, I've got two, perhaps you can just turn off the slides. I'll just speak about the last area that I wanted to speak about, which is mediation and education. And here we are, and there are two projects that I want to tell you about. Both of them that I'm involved in, but both of them just are examples of what is happening in the great world that we are now living in. And I know that in your country, you are doing, because I have a lot of students from India, and India is doing some great things, some really good things in your country to try and work with the dispute resolution alternatives. So the two projects that I'm working on for children and youth is a project for working with Mediation Beyond Borders International and a group from England called Educate Global Climate Change Education. And what we're doing is we're training the teachers to introduce to their students the use of mediation for resolving and dealing with climate change disputes. And so this is a project that we've been working on, and hopefully will be available for you people and the students that you have to use in the next year or so. I hope that it will be done very quickly. And it's called Peaceful Planet, and we're going to be introducing that hopefully this year. The next area I want to speak about is university legal training, and that's really where we are here today. And so there are so many universities. India, my university is a global internet university, so everything's online with my university. But there are universities around the world that now have courses on climate change and sustainability. And so that is really what, when I'm speaking to this group, was looking for new ways, what they want to do with your lives and what you want to do for training. I would suggest you take a very close look at the international environmental law, and you take a good look at having the training necessary to get the work in that area. So I'll speak about the work that I'm doing at Euclid University. We have a climate change and sustainability course, and that is a course, it's extensive, and my small portion of that course is dealing with climate education. So as again, I know that there are courses around the world. I'm very familiar with Canada, familiar with what's happening in France as well. So as I said, I know as well in India there are a lot of materials that are available for you. So my suggestion to the people who are listening to this conference is this is one of the ways to go. So I'll go then to the last slide, or not the last, but close to the last slide, which is to show you exactly what I'm doing. And I will show you the books that I've written. So here we are. Here's the book that I've written. It's called, let's see if, we can't see me. Oh yeah, we can see me. Here I am. And here's the book. It's Creating a Masterpiece, The Arts and Climate Change. So it's available on Amazon. But what this book is about, it raises awareness about climate change through the creative arts. But it does more than that. It talks about the groups and how they are working with communities, working with different areas to try and move towards climate action. So we're doing something. So as I said at COP26 when I made a presentation, we're responding to Greta and her blah, blah, blah comment. We are doing something more. So the United Nations Framework Convention on Climate Change, it's doing its very best to try and get things happening. But similarly, books like this and the children's book that I wrote, and I'll just show you that one as well. And that one's called Life on, let's see if I didn't put that on the materials, but it's called Life on Planet Earth, My Story. And what it is, it talks about biodiversity, it talks about ecosystems, it talks about the Paris Agreement, and it lets the children tell their story about their life on Earth, looking at these designs that are in the book and looking at the words in the book, and then the children write the story. Similarly, the young people that are listening to this presentation, it's your story. And I want to invite you to work in the area of climate change and sustainability. And with that, I want to thank everyone. Oh, I had provided one last slide, which is a set of endnotes. And in those endnotes, the endnotes provide the material that you need to show the work that I've done. So you can go through that. It has my presentation. You can click on the button, and it's about a half an hour presentation that I made at COP26 in Glasgow. And then the final video was a YouTube video. I don't think we now have time to go through that, but it just showed the reaction. We might have, if we have 2 minutes, we can at least, if somebody can click on it, it will show the reaction of the French people when they won that case, the Affaire du Siècle. Are we able to click on that? Are you able to do that, Mr. Anashi? Or Mr. Kumar? I don't know. Are you able to click on this and, can you make it work? I mean, when I click on it, here, okay, can you click on it? And then what happens is it will show the people's reaction from France. I can't click on it because it's open. Can I click on it? No, I can't click on it. No, I can't do it. Oh, you guys have to do it. You'd have to just click on it and it doesn't work. Anyway, what it shows is the people's reaction, and they're very inspired by the fact that the arbitration court said, you haven't done enough, you have to do more, and they were given deadlines as to what they could do. So with that, I will say thank you very much for your attention, and I hope that, I don't know that if we have time for questions, great. If not, hopefully we'll have time for questions at this conference at some point. So thank you very much for your attention and your invitation to join you. Thank you.
Yeah. So if any students you have any queries, you can please unmute yourself and speak. Yeah, and apart from that, there are opinion polls going in the chat, so you can participate in that as well.
Okay, great.
Yeah, you may proceed.
Okay, thank you very much. I'll turn my microphone off now.
So further, I would like to thank Dr. Charlie Gaiden for her intellectual speech on the subject, which enthralled the hearts of our audience. Now, I would like to invite Mr. Ashok Panikar, the founder and director of Metaculture, to commence his speech.
Hello. Can you folks hear me?
Yes, sir.
Wonderful. Well, firstly, thank you so much for the opportunity to talk with a group of young people who are interested in the field. As you probably know, if you read my bio, I have been a mediator for more than 20 years, and I've been a conflict management professional even before I started mediation. So it's close to almost 30 years. And today, after having listened to Dr. Vargas, Mrs. Karbanda, and Dr. Gaiden, thank you, Mr. Shravan Kumar, for your introductions. I just want to say that my presentation is going to be a little different because each one of you has come with a lot of really vital information about the field and the ways in which the Indian judiciary and the government are helping make some of this happen. A lot of it is very welcome because I was in India, or my company, Metaculture, was practicing in India from 2005 to 2016 when we left, and we are now in Washington, D.C. And the reason why we left is a complicated one, but it's primarily because the climate, the larger climate, did not seem to be very suitable for alternative dispute resolution. And I'm glad to see that there is so much happening right now. So without further ado, I'd like to start my presentation. So a question, is there a way I can share my PowerPoint so that I can switch the slides, or does it have to happen at your end?
So you can.
Okay, so excellent. So share, there must be a share button. Oh, present now. Right. My entire screen. Can you folks see my screen now?
No, sir, we are not able to see your screen.
Oh, okay. So I want. Am I clicking the right thing?
Sir, you have to click on that portion of screen, and then you have to click on entire screen. First, click on the portion which is showing your screen. Click on that portion, and then you have to select your entire screen, and then
oh,
share. Are you
sorry.
able to?
I have no idea what I'm doing. I apologize. But there is one button which says present now. Is that the one?
Yes, sir. Yes, sir.
Okay. And your entire screen?
Present now your entire screen. Then
Yes.
you will get like this something on the screen. There is written share your entire screen. Then Chrome wants to share the contents of your screen. Click inside that. Click and then share.
Got it. Sorry for the confusion. Can you folks see my screen now?
Yes, sir.
Yeah.
Excellent. So thank you so much. And I'm just to remind everyone, like many people who come into mediation and alternative dispute resolution, we come with very specific values and ideals. The growth of mediation itself over the last 40 odd years has been because of a reaction to what many saw as an increasingly violent propensity that we have in terms of dispute resolution, whether it is at the interpersonal level or at the larger international level. So I want to I would like us to kind of take a step back from the specific processes of mediation or arbitration and to contemplate for a moment the larger values and the culture of the world that we are working or trying to do mediation and nonviolent dispute resolution in. So you are also very aware that over the last 5 to 10 years, the geopolitical environment has become very messy. By that I mean, when we look at what's happening in Ukraine right now, when we look at what's happening in Taiwan or a little earlier in Hong Kong, and when we look at many countries today that are becoming more authoritarian, we have to ask ourselves how mediation, which was at one level the antithesis of authoritarianism, how mediation fits in. So, very quickly, and if you want to put down your thoughts on chat, you may put it down. I have just put down what I consider as some of the key values behind the practice of ADR or mediation itself. And for me, the first one that came to mind was about the idea of justice itself. How can we ensure that even the weaker parties in a conflict have some possibility of being given a fair shot? The second is the notion of equality. This is a very big one because when we talk about mediation, we talk about giving people a voice, even those who do not have much power. Then the idea that we do not need to use power or violence or force in order to come to a resolution. Now, these might seem pretty self-evident, but I want to show how these cannot be taken for granted at all. Then the idea of participation. In other words, that many people do not and have not historically had a place at the table. And what the conflict resolution, as we understand it, does is it provides a space at the table for people who would otherwise be marginalized, otherwise would be excluded. Similarly, the idea of compromise. which is compromise is a dirty word in many parts of the world, in many sectors of society, because it's seen as somehow selling short. And yet, in mediation at many levels, the value of compromise is something that we have to be open to. And then, of course, many people come into mediation or arbitration because it's efficient, it's cost effective, it is faster, it gets the job done in many cases. It prevents extensive, complicated, and ugly litigation. And I'm sure there are other values that we prize because of which we come into mediation itself. So, if we look at this, then we have to also look at the kind of social systems that promote these values. And by this, I mean that every society doesn't value equality or justice the way you and I might appreciate it. And this is something that I have come to understand after working in many different countries and in different domain areas, that the kind of values that are predominant in a society have a lot to do with the specific society and its culture. So all societies are not equally open to diversity and tolerating differences. I've worked in societies where they're very clear that diversity is a bad idea, that they want the dominance of a homogeneous tribe or clan or one way of thinking. The second is the idea of greater egalitarianism and less hierarchy is also questionable in many societies. In India itself, and I don't have to go into the caste system alone, but the fact is, for many people, equality is not something that they aspire for, particularly if they have power. So we cannot take for granted, as I do very often when I'm working in a more Western environment, I can't take for granted in certain parts of the world that equality or egalitarianism is prized or is valued. The other thing that I discovered working in countries like India, and now I would say even in parts of the West, is that all these wonderful things, dialogue, negotiation, mediation, they take time. Even if in the long run they are time economical, the fact is it requires us to slow down, it requires us to listen to each other, particularly under very difficult circumstances, and it requires us to have the time to negotiate, particularly with people that we may not agree with or with people that we are deeply offended by. Similarly, if at a social level these values are tricky, at a political level these values are probably even more at threat. So, for instance, these values very often go with what I call a free and open democratic system where the rule of law is prized. So in many parts of the world, including in many parts of India, where I did this work, rule of law is there on paper, but it's very difficult to enforce it. And this makes mediation or conflict resolution, including large group work, very, very difficult. Second, it's also more likely that the political systems that value the larger values of mediation and ADR tend to be liberal and secular. Both these terms are under attack now. In many parts of the democratic world, illiberalism is growing. Countries like Hungary are talked about very often, and even countries like India. Even secularism, the equality of religions, is actually being questioned in many parts of the world. The last is what I am personally spending a lot of time working on, which is the development of a mature and skilled citizenry that has the capacity to participate in these negotiations, in these mediations, in a liberal society. It can't be taken for granted. So I have a bunch of questions that I would like to offer mediators. The first question is, are we really clear about our motivation for doing this work? Why exactly are we taking on mediation or arbitration or conflict management, which is what I did? Why are we motivated to do this work? Is it because of our passion and our idealism? We want to create social and cultural change? Or is it because it's becoming, unlike when I started out, a more reputable profession with the possibility of our earning a reasonable income? Is it because of status? Because I know that particularly around 10 years ago, 15 years ago, suddenly in my social and economic and professional classes, mediation, particularly in the West, became a reasonably high status field. In other words, you met people socially, and they would talk about the fact that, yeah, I'm not on Wall Street. I'm not an engineer. I do conflict management. I was in Israel or Palestine, and I'm last week, and I'm going to this conflict zone next month. So status may have something to do with this for some people. Then there's creativity. I personally know that mediation, dialogue, ADR is phenomenally creative. But is that really our key motivation? Knowing what our motivation is very important. The second is, when we come into mediation or ADR or conflict management, are we approaching this any different from civil engineering or dentistry or the teaching of biology or English or French? What's the difference in terms of not just skill sets and knowledge base, but what's the difference in terms of disposition? Is the mindset of an ADR professional different from that of a plumber or an accountant or even a researcher? And this has huge implications for me because I have trained hundreds of mediators. I don't mean just 2-day training programs, but I have mentored and coached people for the past 20 years. And I realized that everybody doesn't come into this field with the same or with a reasonable common framework within which to practice it. So it raises the question, how do you function if you are living in an illiberal or an authoritarian society? I know that a colleague of mine was working in China about 5 to 8 years ago, and he went from the West, and he said, it's great, China is wonderful for doing this work, provided you do not question anything. So in other words, if the work you do in bringing multiple stakeholders together doesn't question or threaten any of the axioms of the Communist Party and doesn't challenge anything about Chinese society, then there are enormous opportunities. So my question for all of us is, could you or I continue to be mediators under a dictatorship? However you define a dictatorship, because obviously you can have it on a continuum of more oppressive and less oppressive. Second, could you continue to be a mediator if the work you do upsets the majority community? There are many parts of the world now where freedom of speech is under threat, and people are paying a price for even articulating certain values that are seen as threatening to the dominant group. My question to mediators and wannabe mediators is, would you be a mediator if you could only do commercial or family mediation as long as you do not upset cultural and religious norms? And a couple of examples of countries like that may be the UAE or Iraq, where there are very clear boundaries in terms of what kind of not just solutions, but engagement is considered acceptable. Could you do political, environmental, or cultural cases, complex multi-stakeholder cases between governments and corporations and civil society? Could you do that in a society where you are not allowed to maybe even advocate for that kind of work? China is a great example. I tried doing some of this work in Singapore about 10, 12 years ago, and I found even the Singapore mediation folks just shut it down completely right in the beginning because they didn't feel the government would be open to it. So here are my key questions. What are your alternatives if you are a mediator and you wish to practice in an increasingly illiberal or authoritarian society? And how do you create an environment or a market for non-commercial mediation? I'm focusing on non-commercial because seriously, even a dictatorship would be happy to have arbitration, mediation for commercial cases so that they can get the problem out of the way and continue and help the businesses continue to grow. China is a great example of a capitalist dictatorship. So that's where I'm going to leave it. I run a lot of programs, online 12-session programs. My next course is on personal, organizational, and civic relationships, and it's on Tuesday, starting from March 1st. If you're interested, do give me a call and get in touch with me. And otherwise, I am done with my presentation, and I am happy to come back to the screen if I can. I would really appreciate any questions that anyone has, if you have time for it.
Yeah, sir, we have a time for it. So students, any questions? If you have any questions, you can ask and get your doubts cleared.
I noticed we didn't have too many questions for the previous speakers. So perhaps this is very late in the evening for Indians, or it's a very hidden group. So
Shaheen, Aditya, Sajida, Anil, anyone? Any questions? Gargi, Harsha, Kajal, Kavita, Kirti. Any questions you have? Dispute resolution, arbitration, area. Okay. Yeah, Anay Khandalwar. So, would you like to unmute yourself and speak out, Anay?
Anay, I'm waiting for your question. Okay, you're going to type it on chat. Perfect. And is it for me, or is it for any of the other speakers, or is it for all of us?
Surya, Sonali, Shrikant, Simran, Siddhi, Shubhashri. Everything clear? Yeah. Anay, if you could type a question.
Incidentally, the other speakers, I have put my email down. I would welcome hearing from you and being in touch with you, Dr. Gaiden, Dr. Vargas. It'll be great to be in touch.
Thank you. Do we have the question? Thank you very much for that invitation. You put it in the chat, your email?
Yes, I put it in chat. I don't know if you can see it.
No. I don't know where it is. Here we are. Here it is. I've got it. We've got it. Okay.
It says ashok@metaculture.studio.
Yeah, thank you very much. Do we have the question from the student?
Mr. Anay Khandalwar. If you could just unmute yourself and speak, or either type it. Okay.
Yes, Anay said culture is different, right? Go on. So what's your question, Anay? Oh, what according to you is the best culture? I think that's the kind of question that is very difficult to even speak out aloud. So I'm going to kind of deflect, and I'm going to say that it's not a question of what culture is the best one. I would merely say that in my understanding of alternative dispute resolution and mediation, the cultures that are most receptive to this work are those that have some kind of an aspiration for equality and egalitarianism. In other words, at least theoretically, the stakeholders must be willing to listen to one another, even if one of them has very little power. I have experienced in India, for instance, but also elsewhere, very powerful stakeholders refusing to even come to the table because it's beneath them to even engage in a negotiation with people that they see or groups that they think are way below them, either financially, politically, or even in terms of social class. So the first thing is, if we genuinely wish to practice mediation and alternative dispute resolution, that the culture must be receptive to creating at least temporarily a level playing field. And by this I mean you need to at least bring people to the table and not expect that the powerful stakeholder will expect or can expect that his perspective is valued above the perspective of the other stakeholders. So that's the first thing. The other thing that I would say is that dialogue and negotiation take time. In my experience, the first thing, I mean, it's like from 1995, from 2005 onwards, I kept hearing from all classes of society that talk is useless. We need action. This is obviously international, global kind of attitude. But in India, I found this to be far more powerful, and it was a reason for not engaging in dialogue. And including civil societies that do wonderful work in the environment and labor and women's rights, they didn't want to talk because they see talk as cheap. They want action, and that action is usually protest. You see, the Indian civil society has been so seeped in an adversarial approach towards dealing with government and dealing with the corporations that there is very little patience for sitting down and listening to alternative perspectives. This was the primary reason why after 10 years and doing a lot of work in India, I left the country, because I found leave alone corporations, leave alone government, which have their own restrictions, but civil society didn't want to engage in complex dialogue. And that for me is something that comes out of the culture itself. So I don't know if that will help you, but that's just why I talk about the importance of culture. Thank you.
So my question for all of you, Gargi asked the same question. How can we differentiate between arbitration and mediation? Because as I know, almost the concept is same. Like in both of the cases, we are settling the case out of the court, right? It is not like the normal case which is inside the court and the judge gives the decision. So what is the basic difference between arbitration and mediation?
Charlie Graydon, I'll speak to that from my perspective. The difference is, I mentioned that earlier in my presentation, mediation, the people, the stakeholders are in control of the results. So all of the stakeholders, whether it's just a dual situation for mediation or whether there's several stakeholders, everybody has a place at the table. With arbitration, we hand the decision-making over to someone else, someone who is skilled in the area, but it's not the parties themselves who are negotiating or finding or are coming to the result. So that would be my distinction between the two. But I'm very happy to
in mediation, do we need a party like a mediator? There is a need for the mediator, right? In an arbitration, there is an arbitrator who takes the decision. So is it in like mediation, like you need a mediator to take the decision?
From my perspective, as a mediator, I don't make the decisions at all. I leave it to the parties to make the decisions. I know that in some cases, the parties want you to make those decisions for them. And my position is, I don't make decisions. I'm here. I can guide you. I sometimes caucus with people that might give some ideas about where you should head. Or from my perspective, but at the end, it's not my decision to make. It's up to the parties to bring their material to the table and to make their own decisions. So, and again, I'd love to hear from other people on this. That's just my approach to dealing with mediation. Other people might take it. I'm fairly aggressive as a mediator in the sense that I do caucus probably more than other mediators because I do sometimes feel that there could be you can get people unstuck when they're stuck with problems. You can unstick them by saying, okay, calm down, think about this opportunity. So again, I'd love to hear from others because people have very different approaches to mediating disputes. So.
Well, the basic difference that I'd say really it is mediation is more facilitative and not directional. And definitely, we are not allowed to take decision. We are not allowed to even suggest. As a mediator, you are not even allowed to suggest the recourse. You have to be very patient, and it's basically you are just facilitating the parties to come to a decision on. You're trying to, you're trying to help them in the journey, and definitely, if I'd say in a common words, a laid back, laid back in the sense of behavior, in the sense of emotions, but not in the sense of participation. A laid back in the sense of their decision, their dispute.
Okay. Thank you, ma'am. I would like to thank Charlie Graydon, ma'am, and I forgot your name, ma'am. Sorry, Rectitude Dispute Resolutions. Thank you, both of you. Gargi Bandari, ma'am. Thank you so much.
Thank you, Riddhi and Mr. Kumar. It was a wonderful session, and it's a good work that you guys are doing and promoting new entrepreneurs and giving them a platform to their ideas, to depict their ideas, to speak up, and that's a really good job. And please keep up this good spirit. Thank you so much.
Yeah, ma'am. We are pleased that you all international speakers are here with us on this amazing journey, and we would like to be the part of this journey for a long time. And thank you so much, and have a great day.
I would like to thank all the guests for this fantastic speech in today's conference. I would also like to thank audience and young researchers for listening to us so patiently throughout the conference, and request all of you to join us tomorrow at 7 p.m. for the second session of the conference. Until then, goodbye, take care, and have a nice day. Keep your spirits high.
I'll just say thank you to everyone. Thank you very much for the invitation and to allow me to make this presentation. So thank you, and hope to see you for the rest of the conference. I'll do my best to connect. Thank you.
Yes, thank you so much, ma'am.
Thank you very much for the opportunity to be here. Thank you.
Thank you, ma'am.